If the judges get a reputation for being liberal, more liberal than the population, that is a problem. They should be neither tough nor liberal. They should just be doing what the politicians are prescribing in legislation.
What matters to a judge, I think, is that we are fiercely independent, and not having the Lord Chancellor being in the cabinet and appointing us, I think is a good thing.
Making public statements on controversial political issues from a retired, very senior judge does make you wonder, as a member of the public, well, this person is actually highly political. I think it's quite damaging.
A risk, I think, for the judiciary is in an increasingly fissured world. Very strong opinions on both sides of a fairly evenly divided political system. The risk of people turning on the judges is increased.
This is The Judges, Power, Politics and the People, hosted by the University of Law.
Good evening, and a very, very warm welcome to everyone for this finale event of our landmark podcast series, The Judges, Power, Politics and the People. The series has involved 9 of the most senior former judges in England and Wales, speaking with Frances Gibb, former legal editor of The Times, and it has been a resounding success. This is the first time that all these distinguished and influential leading figures have been interviewed as part of one series, and it has provided a fascinating insight into their careers and indeed their lives. As many of you will know, the podcast has sought to learn a little more about the men and women who occupy the pivotal judicial posts of Lord Chief Justice or President of the Supreme Court. Their views about their time in office, key decisions, any regrets, and their dealing with ministers. The judges have reflected on their careers and motivations, and they comment on the changing balance of power between the judiciary and the executive in recent years, and indeed on points of tension. We shall first watch a short compilation of some of the insights of the series, and then Frances will introduce our panel of speakers for tonight. They will give their thoughts on a couple of the main themes, and then there will be an opportunity for the audience to ask questions. Thank you.
Your ruling led to the infamous headline, Enemies of the People, and a huge outpouring of vitriol against you and your colleagues.
For major national newspapers to throw abuse at the judiciary in that way and use a phrase that was redolent to Robespierre, Hitler and Stalin was just unacceptable in a modern democracy.
Far from being anti-democratic, the court was protecting the democratic institution from the overreach of the executive.
You would turn or expect the Lord Chancellor to stand up and defend you, this being Liz Truss at that time.
It suited the political circumstances of the time not to say anything.
She wanted to keep in with the popular press, or the right-wing press.
That's what I surmise.
More than sticking her neck out and defending the judiciary.
Yes.
The Enemies of the People was a ridiculous situation in the judgment of what the judges had decided.
You effectively got rid of her from that position.
It's always difficult to say. Her period as Lord Chancellor showed the issues that will subsequently arise when she had more senior posts, particularly that of Prime Minister, of someone who doesn't listen, doesn't take advice, and doesn't understand the Constitution.
We were not in the slightest bit concerned about whether Brexit should happen or not. We were concerned with the respective roles of government and Parliament. It never occurred to me that there would be such a focus on the particular brooch that I was wearing.
Did you choose the spider that morning deliberately, with some thought in mind?
No, not at all. No, not at all. I chose the dress deliberately.
It must have been a bit of a nerve-wracking moment, was it?
Everybody listened to the summary of the judgment, which I delivered in complete silence, apart from when I said, "This is the unanimous decision of us all." And there was an audible gasp then.
I can't believe how Brenda Hale got 11 Supreme Court judges to agree. It's almost unheard of. Well, there've never been 11 before, but it's very difficult to get them all to agree.
Astonishing.
And particularly one or two of them who are friends of mine who disagree on principle.
What do you think happened? How did she manage it?
I don't know.
A three-line whip?
I did actually. I think the seriousness of it.
Were you surprised that you achieved unanimity on it?
Well, I'm not sure that I achieved unanimity. We achieved unanimity.
You did, but you were chairing the...
I was chairing it, and
committee.
I did my best to enable us to reach conclusions quickly.
You overruled the Lord Chief Justice. So did those judges in the High Court get it wrong?
Well, of course they got it wrong.
You famously led the ruling that Boris Johnson's suspension of Parliament was lawful. And then you were even more famously overturned. I'd like to ask you, first of all, how you felt about that.
It would be extraordinary if any judge got too worked up about being overturned. The Supreme Court decided that the prorogation of Parliament was not a proceeding in Parliament. That wasn't argued in front of us. It wasn't actually part of the case that was argued before the Supreme Court either. So that was part of the decision that I at least was surprised about.
We were all brought up to believe in the sovereignty of Parliament as the fundamental principle of our Constitution, not the sovereignty of the Prime Minister, not the sovereignty of the government, the sovereignty of Parliament. This was established in the 17th century.
I think our judges were very taken with the idea that it wasn't actually for them to interfere.
Quite, but if it wasn't for them...
You're saying, who was it for?
Who was it for? That's what the court's there for.
If the government had won that case, it would have left a serious constitutional void. It would have meant that a public power, which is what the prorogation power is, would have been exercised without the government being answerable to anybody. Not to Parliament, because it would have been prorogued, not to the electorate, because there was not to be an election for another 3 years or so, not to the monarch, because by convention the monarch's prerogative powers are exercised by her ministers.
We had the three most senior judges in the jurisdiction. We formed our view. My decision was subject to review by another court, and there it is.
People looking at it from the outside and thinking now of public perception will find it astonishing that you, the most senior judge in the land, two other very senior judges, and then you get 11 who just say, no, that was completely wrong.
Well, I don't think they put it quite as crudely as that.
There was talk of certain chambers being not prepared to accept somebody of a Jewish background.
Has that changed, do you think?
I think it has.
No woman went into commercial or civil work. There were 64 women and 2,000 men when I was called.
It was difficult. It was difficult for women,
and there wasn't any work. But such work as there was, apart from the criminal bar, such work as there was, they wouldn't give it to women.
I felt a great responsibility if I was the first, not to be the last.
I took the view, unlike Brenda Hale and Mary Arden, that my job was to make sure others would follow me. So I kept very quiet.
I was very visibly a woman. I did take steps to make it clear that I was visible. You know, I didn't just try and dress as much like a man as possible.
Brenda was horrified with me because she thought I should have been standing up, as the woman in the Court of Appeal.
I'd always wanted to be a success as a judge. I wouldn't have been interested in the job if I wasn't a success.
It was a period of my life when I was really stressed. I couldn't sleep. I actually went to a hypnotist to try and see if he could hypnotise me into sleeping at night.
Your family worried that you might even be on the verge of a nervous breakdown.
No, I think I probably was.
My father gave me extraordinarily good advice, 2 bits of advice. One was, you've got too high a voice, bring it down. But yes, I did have regrets.
Did you ever lie awake at night with some of these cases?
No, because my father's other advice was, at any level up to the Supreme Court, you can always be reversed, so don't worry.
Sometimes you agonise and eventually you work out, yes, this is what I think, definitely. But sometimes you do feel, sometimes even when you're just handing down the judgment, you think, did I get this right? But a point comes where you've just got to say, this is it, I've got to get on.
Do you have any particular regrets yourself?
That's a question I wasn't I wasn't expecting. I don't lie awake at night. I just don't. I struggle to see actually how anyone could hold down a really demanding job if they really did lie awake at night.
I decided 250 cases in the Supreme Court about. It's inevitable that I was wrong in some of them. And judges do get things wrong.
Where do you put yourself on the spectrum of the hard and soft sentences?
Very, at the extreme end of the soft, I would say.
It's quite easy for politicians to castigate judges for being soft. Lord Wolfe was, referred to as the burglar's friend, and it was horrible.
You are a Liberal judge.
That's your statement. I think I'm doing what the case requires.
Lord Wolfe was famously called the burglar's friend.
Exactly.
Do you think these are fair comments from the tabloids or the public?
No, of course not.
We've had a run of quite liberal senior judges.
Well, you say quite liberal. By comparison to what is the question?
I suppose going back 50 years, hanging.
No,
but we don't have...
We don't have hanging, but that was a political matter.
Out of step with the public normally means out of step with a particular newspaper.
Sometimes the public doesn't appreciate that if we locked up everybody, they think we should, for as long as they think we should, no way the country could afford to keep the number of people in prison, and people can reform.
Where the public are actually consulted and given a detailed scenario, they tend to be much more lenient than you would expect on sentencing.
I think our criminal sentencing is, and certain aspects of it when I was a judge were utterly unacceptable. IPP and that sort of thing.
Yes.
And personally, I think our sentencing is savage, in many cases, quite inappropriately high.
A system which locks people up like animals in cages for 23 hours out of 24 is basically inhumane.
Do we have a good system?
No, I don't think we do.
We must reserve long prison sentences for very serious offences. The scale is constantly rising.
Undoubtedly, I would say we lock up too many people for too long.
After I'd been round Holloway, I just thought, I'm not going to send a woman to prison.
Because of the conditions?
Just inhuman, I thought.
It's important that we understand the effect of keeping to the rule of law in our country. I think it's a very important thing to do.
It's almost like a religion, the rule of law. It gets into your bones if you practice law.
Politicians generally don't really understand the judiciary, and if I'm being honest about it, don't really have it in their bones a feel for the constitutional arrangements that we have.
I think that Boris Johnson did have a contempt for Parliament. The test of a democracy, particularly a functional parliamentary democracy, is not whether it stops complete charlatans from getting to the top.
Are you saying he is a complete charlatan?
Yes. I think the test is whether it enables them to get rid of him once the mistakes are discovered.
And it did.
It did.
In the old days, the Lord Chancellor would uphold the rule of law. He would see it as his job to make sure that his colleagues appreciated the importance of the rule of law.
Do you think the Lord Chancellor should be a lawyer?
Yes, I do.
Do you think they're in a weaker position because they don't have a person such as yourself speaking up for them in Cabinet?
Well, I think that may be a problem.
Having the Lord Chancellor, with all his really important statutory responsibilities and constitutional responsibilities, lumped together with prisons and probation, has meant that the focus not only of the ministers, but also inevitably of the department, is principally on those things which are politically difficult.
I don't remember having to deal with somebody who'd run out of prison.
There is a challenge, I think, to our constitution, which is that running the country technically is so complex now that the idea that you will have laws properly debated in the House of Commons is no longer really realistic. And Henry VIII clauses are almost inescapable to give government the flexibility it's going to need to run the country. We signed up to the convention not because we thought we needed to put our own house in order, but in order to support an international court that would have an international jurisdiction, particularly for other countries where human rights were not as respected as they are in this country.
We have had more populist leanings in the last 2 or 3 administrations in this country, and there have been mutterings about discarding the convention. Do you think that would be a bad mistake?
I think it would be a very bad mistake.
I've expressed my view that we should come out of it. It's a view that I've come to recently and reluctantly. The problem about the Strasbourg Court is that it has, since the 1970s, emancipated itself from the text of the convention, which is the only thing that the states have ever agreed, and given itself a roving brief over large parts of the whole range of social policy. I really don't see that the Strasbourg Court, which is a very ideological court, is going to reform itself.
Leaving the convention would have very wide-ranging consequences, and it's not something personally that I have been persuaded is remotely necessary as a result of the particular difficulties that seem to animate some of our politicians.
If you have subjected yourself to a court, and it was our voluntary decision to do so, then you have to take the rough with the smooth. And if they've decided they have this jurisdiction, then you ought to follow it. You can't expect others to respect the law if you say you won't respect the law of someone else.
I certainly think that we should remain a signatory to the European Convention, because I think it's part of what holds Europe together from the point of view of law.
Well, welcome everybody, and thank you for coming tonight. And thank you for the kind comments, Professor Nolan. I'm Frances Gibb, and I'll start by introducing our distinguished panel. Lord Neuberger. David Neuberger is one of the most eminent judicial figures. He was the President of the UK Supreme Court from 2012 to 2017. Before that, he was a law lord and also Master of the Rolls, head of the civil justice system. It fell to him to lead the Supreme Court in one of its most high-profile judgments in recent years, ruling that the government needed the approval of Parliament before triggering Brexit. He is also Chancellor of the University of Law, and he sits as an arbitrator. Lord Grabiner. Lord Grabiner is one of the leading figures, one of the heavyweights, we could say, at the commercial bar with a caseload to match. He is head of One Essex Court Chambers, which he founded, one of the handful of top commercial sets. He is a bencher and has sat as a recorder. He became a Deputy High Court Judge in 1994. Dame Elizabeth Gloster was the first woman to be appointed a judge of the Commercial Court after accepting an appointment as a High Court Judge in 2004. She went on to be appointed the judge in charge of that court in 2010 until she was promoted to the Court of Appeal, where she sat until 2018. She is now a full-time international arbitrator. Lord Falconer became Labour's Lord Chancellor in 2003 and oversaw the constitutional upheaval under Tony Blair, which involved creating a Supreme Court for the UK, scrapping the Lord Chancellor's role as Speaker of the House of Lords and head of the judiciary, and introducing a Judicial Appointments Commission. In 2007, he became the first Secretary of State for Justice, bringing together courts, prisons and justice policy under one roof for the first time. Welcome everybody, and thank you for coming. I'm going to start off. One of the aims of this series was to shed a bit of light on our judges, the ones who held the most senior positions, about whom we actually know very little. So I'm going to start by asking our panel what they think about public perceptions of the judiciary and the current public standing of the judiciary. What kind of image do judges have? And I think I'll start with Lord Falconer being the only non-judge on the panel.
I think that the judges are in very high standing in the eyes of the public. I think that if you look at great crises that occur, for example, the post office scandal or the inquiry into what happened after COVID, we go straight for a judge, and Heather Hallett and Wynne Williams, the two judges involved, are people who people have the greatest faith in. The reason people have the greatest faith in the judges is because they're incorruptible, they're incredibly high quality, and they are completely committed to the obligations of being a judge, which carries with it independence and a lack of prejudice. So I think the standing of our judges is high. I do not think the problem for the judges going forward is their standing in that sense. I think the difficulty is that reflected by the enemies of the people headline, which is they are perceived to be in play as a group of liberal, remaining, London-based people who perhaps don't reflect a whole world view. And that's not to do with their integrity or their quality, but are they on one side of a woke Remain line? And I think that's the danger going forward for the judges.
Indeed. Liz Gloster.
Well, I don't want to agree with Charlie all the time, but I think that's right. I think that the problem is that although actually judges are fearlessly independent, don't care what politicians think, plough their own furrows, if that's the right word. Furrow, I'm sorry. I think there is a concern, and probably a wrong concern, that judges are white, pale, male, when actually today they're simply not that. They reflect all parts of society. And I say to people who want to be judges, it doesn't matter what you are, who you are, where you come from. What matters is your integrity and your ability and your objectivity. And I think the modern judiciary does reflect that. It may not have done so when we all started, but, you know, hey, there's been a Judicial Appointments Commission for some time now, which, Charlie, I think you put into place. The judges are real people reflecting all kinds of views of society, and that's what they want. Of course, they're not going to reflect necessarily the profile of the criminal population, you know, those with convictions, but why should they?
I think Charlie has a point, though, doesn't he, that judges are perceived as being all of one political with a small p persuasion, of the same groupthink, maybe that's the word.
Well, I think that's rubbish. I mean, the amount of rows I've had politically or otherwise with my colleagues on the bench are quite legion.
Right, Tony Grabiner.
Thanks, Frances. I mean, I agree with what's been said so far. And I do think that the magic is still there. And by that I mean that in the mind of the great British public, there is enormous respect for judges, you know, performing their judicial function. And I think that's excellent. What I'm a little bit concerned about is the modern willingness of retired judges. I couldn't possibly name anybody, but Jonathan Sumption I got well in mind. And I feel quite strongly that that people should keep their mouths shut. Not because they shouldn't be free to speak their minds, that's fair enough. And we all have our views. But I do think that the effect of making public statements on controversial modern day political issues from a retired, very senior judge does make you wonder, as a member of the public, well, these people or this person is actually highly political. And I just wonder how far it was appropriate for me to assume all those years that they were magically not political, or they were apolitical, and they were coming to the problem, you know, literally and strictly as lawyers. So I think it's quite damaging for senior retired lawyers to participate in controversial public debate, and indeed to lead that debate, and indeed to have a view on literally every issue that's on the table.
Well, we can come back to that. I mean, if that's damaging, what about judges appearing more on camera, as here, or indeed being on camera in courts? David Neuberger, does that enhance their image in the eyes of the public? We see judges more.
I've always thought that cameras in court are inevitable and sensible. One of the most fundamental aspects of justice in our system is open justice. You see the hearing, any member of the public can come in and watch a hearing. The judge has to give his or her decision in open court, save in exceptional circumstances. And if that's right, then why shouldn't you have the camera there so everybody can see it? I think in terms of threats, first, I think that the problem of judges seem to be an elite or a small group has some justification in the sense that virtually all senior judges have the same history in terms of having been practicing members of the bar, occasionally practicing solicitors, one or two practicing academics. But coming from that training and experience as mostly as barristers, I think there can be seen to be a consistency of approach and consistency of outlook, which in many ways is desirable because it means that you get consistency of decision making. But the price is that they are seen to be a somewhat limited group. As Liz has said, you talk to the judges, you talk to your colleagues, and you realise they have all sorts of different views. The other risk, I think, for the judiciary is in an increasingly fissured world where internal politics, you see it particularly in America, but you're starting to see it here, you're seeing it in Europe, very strong opinions on both sides of a fairly evenly divided political system. The risk of people turning on the judges or one group turning on the judges is increased. We've been very lucky in this country, partly because we have a limited constitutional role, unlike most other countries, partly because we do have a high-quality judiciary. The judges have been largely exempt from attack. The enemies of the people point was shocking, but it was partly shocking because it was something that simply hadn't happened before, and fortunately hasn't happened again. But I do think we have to watch out for that.
Okay, just briefly before we move away from public standing of the judges, what difference do you think it will make, if any, having a lady Chief Justice? Liz?
Well, obviously it'll make a bit of difference, but if you ask me to say, well, what about? I mean, she's going to have her own views. Are they particularly female views or feminine views or girly views? No, of course not. They're her views as a person, which she's developed over the years she's been at the bar and been a judge. But can I say it's going to be different, her being a woman? Well, I don't think so. But I mean, unlike some of one person we saw on the video tonight, I don't think one has to pretend to be a man. I don't think one has to pretend to be like a man. I think that's ridiculous. Of course we're not.
Yes, Elizabeth. I think you mean Elizabeth Butler-Sloss.
Well, I wasn't going to mention.
Well, I think we've just seen it.
Yeah, we've seen it. I mean, I don't agree with that, but nor do I think there's anything special about being a woman. I mean, you just get on with doing the job, and that's what I've tried to do. And I don't actually buy the approach, oh, it's really special having a woman Lady Chief Justice or a woman President of the Supreme Court or a woman who's the first woman who's the Commercial Court judge. Of course, I was delighted to be appointed by Charlie, as I must disclose, to be the first woman Commercial Court judge. And, you know, it was a term of my appointment, and wasn't I lucky? But I don't really like that approach. It shouldn't matter, because we're all people, we all are what we are, and I can't really get too excited about it, but maybe I'm not defending the sorority here.
No,
so no,
it's a
I
fair
don't
point.
think, I mean, she'll bring her great Sue Carr talents to the role.
I think the only thing I would add there, I think in terms of what the public see, it won't change in terms of views and opinions of what she does. But I think for the public to see a woman in that top
it's
job,
good PR
it's
for the
good.
judiciary.
It's good PR.
It's good PR for the judiciary.
Anybody, any further comment on that, or we?
I just think it's, I go along mostly with what Liz has said. I think it is pretty appalling that it's taken hundreds of years for a woman to get the appointment. And I think it's a very good sign, and it sends a very good signal. But so far as her performance as Lady Chief Justice is concerned, I don't think her sex makes a ha'porth of difference.
I think she's an exceptional person. I think she is unusual in personality terms to be the Lord Chief Justice. She's comparatively young. She is very connected with people in a way that perhaps judges in the past have been more distant. I can't believe that that is not something to do with being a woman. So I think it's a good thing from the point of view of how the judiciary looks but I think she will bring profound change to the judiciary. I think in terms of publicity, it was very lucky for the judiciary that it was a woman Lord Chief Justice, Lady Chief Justice, at the point the Garrick scandal occurred.
The only downside with her is that her family has a strong connection with Arsenal Football Club.
And there is an indication, Tony, of the differences.
We can't hold that against her.
Well, I'm not sure about that.
Tony's
Okay, the public face of the judiciary is probably most seen in sentencing, and particularly now that we have cameras in a lot of courts where sentence is delivered. And I think one thing that came over very strongly to me in the series was the unanimity over the sentencing regime, the criticism of short sentences, the concern about prison overcrowding. It really was one voice I felt speaking there. What can it be? I mean, the government is doing something on short sentencing, but is the judiciary out of step with public opinion on that, and is that a problem? Let's start with Tony Grabiner.
I mean, it's not really my field, but I do have quite firm views about it, inevitably. The prison overcrowding is disgraceful. I mean, these prisons have been devised on the basis that, for example, there should be 2 people in a cell. For the most part, I think there are at least 3 and sometimes more. And the motivation, I suspect, for political demands that short sentences are no good. I mean, I agree that they're not any good for all sorts of reasons. But the reason why politicians clamour for that is because they know that the prisons are overfilled. And the only way of dealing with that problem is to build new prisons, and there isn't enough money available for that purpose. I mean, I think it is a public scandal. And I do think that short sentences are, for the most part, a waste of time. And I think that we don't give enough by way of resource to this very, very important part of what we do. And I'm not sure that we do anything at all worthwhile in terms of improving the quality of life or educating people who are in prison. I don't think we're any good at that at all. But it may be we're much the same as other nation states elsewhere in the world. But I think it is one of the really poor parts of our system.
Charlie Falconer, you've had responsibility for prisons in your time. What can be done about it? It's still as bad as ever, if not worse.
It's worse. And I mean, we're in the middle of a huge crisis at the moment where prison vans are circling the M25 in the evenings in order to try to find a place because the prisons are so full. Sentencing is a really big fissure between the politicians and the judges. The politicians reflect a much more hard line on sentencing, and it was so interesting and revealing the films that you made, because you said rightly, with the possible exception of Lord Burnett, who you didn't have a quote, but he was much more below the radar as to what his views on sentencing were. I think it is really important for the judges to be much more neutral on sentencing, because they, and I myself am liberal on sentencing, but that's not what the judges should be. They should be neither tough nor liberal. They should just be doing what the politicians are prescribing in legislation. It gives them a quite high degree of discretion. You may well think that it's too tough, that prisons are a bad thing, or whatever you might think in terms of a liberal view. But if the judges get a reputation for being liberal, more liberal than the population, more liberal than the politicians, that is a problem.
But if they have a concern about the state of the sentencing regime or the prison, I mean, if the Lord Chief Justice, holder of that position, can't say something, who can?
I don't think he should. I think the question of where politically people should be sentenced, or not where, but where the level should be, is for the politicians to fix. And if judges think it's too harsh or too soft, they shouldn't say so.
They just get on with it.
They should get on with it. And I mean, when 50 years ago, the judges were a bunch of brutes who were very, very right-wing and unpopular as a result with liberal opinion. The judges should be in the middle somewhere. I thought Nick Phillips was very interesting when he said on the softest end of liberal. Lord Wolfe was deliberately trying to avoid saying how liberal he was in relation to it, and I admire them for that, but that's not their job.
I think they were honest. David Neuberger, you were very candid about your concerns of Holloway Prison and other aspects of the sentencing regime. Do you agree with Charlie that it's not for judges to express such opinions?
I think the question of whether judges, and what Tony was talking about, ex-judges, what they should talk about and what they shouldn't talk about is a very difficult topic. I mean, we say ex-judges shouldn't get involved too much in political issues, yet we make them, and used to make them, and still do make some of them, members of the House of Lords, where they are expected after they retire to speak. Similarly, if judges can't talk about sentencing, when the judges are responsible for sentencing, they're encouraged to go around prisons and visit prisons to see what the effect of their decisions is. It's a bit rum. I think that judges do have a function to speak out on certain things. And if they believe they are part of a system that's broken, I think it's a bit rum to say they shouldn't speak out. And when it comes to prisons, I think they are a bit broken. As for judges carrying out politicians' wishes, judges' role is to carry out what the statutes require. And subject to what Charlie meant, I don't think judges do sentence people outside the statutory requirements. They do obey the law. They may go outside what some politicians would like. They may go outside what the Sentencing Council may from time to time prescribe. But then, of course, there is the Court of Criminal Appeal, which will, Court of Appeal Criminal Division, which will put right what they did. But I think there is a duty. I think what I would say about serving judges speaking out is that one of the functions of the Lord Chief Justice, one of the functions of the President of the Supreme Court, in one case the leader of the English and Welsh legal system, in the other case the head of the UK legal system, if you like, judicial system, is to speak out on appropriate issues. I think for more junior judges to speak out is more questionable. But I do think there is a function on senior judges to speak out, and if they're sentencing people to prison in circumstances where they think it's wrong and the system isn't working, then for them to be part of the system and not to speak out seems to me to be wrong.
And does it matter that judges, compared with 50 years ago, as Charlie said, and was mentioned on the programme, does it matter that the judges are much more liberal, perhaps even than the general population?
I think it's a difficult question as to whether they're more liberal. I mean, Nick Phillips in your film made a very good point. If you ask people, are judges too liberal and sentencing too low, they might well say yes. But such experiments have been done of sitting down members of the public with details of particular cases suggest that actually, when you're faced with particular examples, members of the public will sentence people lower than judges would sentence them. So it's quite nuanced. The other thing is that there are certain newspapers that are on a mission to, as far as one can see, to impose or get judges to impose heavier and heavier sentences, and they are seen as representing the public view when they don't necessarily do so.
Liz?
Well, I've got very little criminal experience, with one or two notable exceptions. I certainly think serving judges should not speak out about the level of sentencing. The state of the prison seems to me to be a totally separate issue, which is not actually within the judge's remit. The judges can't do anything about the state of the prisons. But so far as serving judges are concerned, they've got to apply the law. But there is discretion within the law, as any judge who's played about with those awful guidelines, which we're supposed to follow, will know. You can dice around within the guidelines and use your discretion a bit to allow the not so felonious criminal perhaps not to spend so long in jail. So one does have some sort of very limited discretion. But I found it very difficult. The few criminal cases which I did do, I must say, I found the whole sentencing thing incredibly difficult. Once one retires as a judge, I mean, I rather think that that ex-judges, except if they're in Parliament, should actually keep their mouths shut. But
right. Well, finally on prisons, Charlie Falconer, I know you don't speak for Her Majesty's opposition, but if we get a Labour government, are we going to see more money into the justice system? How can this crisis really
there's a huge
be
crisis,
resolved?
and the crisis is, as David and Tony have been saying, focused on the prisons. So you can't speed up the Crown Court without filling up the prisons. So I think the first thing that Labour might do is build more prisons, because unless you can build more prisons quickly, you can't solve the problem at the end of the day. But Harry Wolff said to me once, the reason why more and more people went to prison was because both Labour and Conservative, from the time that Tony Blair became the Shadow Home Secretary, began to talk about being tough on crime. He was also tough on the causes of crime, but he was tough on crime in a way that removed Labour from having been much softer on crime, because that was reflecting not, I think, the Daily Mail. I think it was reflecting what the public expected of the criminal justice system in the light of particular problems, particularly community crime, that they were seeing in their communities. So we'll spend more money on prisons, which will then speed up the system. There won't, I think, be a softening of either the rhetoric or the statutory framework.
Or the actual lengths of sentences. We won't see that
Exactly.
changed. Okay, moving on to probably the hottest topic at the moment, the European Court of Human Rights and the Convention. We have the government apparently, reportedly, the cabinet facing a revolt over 12 ministers threatening to leave the cabinet if Rishi Sunak pursues plans to withdraw from the European Convention. David Neuberger, what do you think about all this?
Well, I'm in the same group as the other ex-judges other than Jonathan Sumption. I think we should undoubtedly remain in the European Convention. I think in the first place, of course, there are decisions of the European Court of Human Rights that you don't agree with, but there are decisions of every court you don't agree with. I think you have to look at it much more broadly and look at the benefits and the disadvantages of being members of the of the convention, and I think it comes down very firmly in favour of remaining. When I became a judge, it was not part of our law. We were signatories to the convention, but UK judges couldn't apply the convention, and the effect over the past 25 years of being able to apply the convention has improved English law and Scottish law and Welsh law and Northern Irish law enormously. And of course, there are some, as I say, some decisions you don't like, some influences that politically some people may not like, but people get obsessed with decisions on things like asylum seekers. And again, if you actually gave people the detailed facts of the asylum seeker cases and understood the issues involved, I think many decisions which were seen to be too, quote, soft, unquote, would be seen to be entirely reasonable. So I would be in favour. It's a big subject. I don't want to go into enormous detail. We've got a lot to get through, but I think it's a no-brainer. And I think the message for countries like Russia and others, if we pulled out of the convention, would be quite shocking.
There's a wider impact. Tony Grabiner.
I completely agree with what David has said. I've got a few other points, though, which I think are quite important. I would say that because I do think them. But the history is very important, because when we passed the domestic legislation that David referred to, the Act actually says that our courts should take account of decisions of the Strasbourg Court. And that was subsequently interpreted, I think, by a court led by Lord Bingham to mean not that they would simply take it into account, some particular precedent, but they actually would regard themselves as being bound by that decision. With great respect to the person I regard probably as the greatest of our sort of post-war judges, present company excepted, of course.
I was just going to say that, Tony. Mind your step here.
I entirely agree with you.
Yeah,
He's a great man.
but he's an outstanding guy. But I do think, with great respect, that was a wrong decision. I think it was made for the right reasons, because I think he was trying to produce an environment in which we achieved a cross-European commonality of law on a key issue, namely human rights. So I entirely understand and respect that. But with the benefit of hindsight, I think that what has become apparent is that there are jurisdictions within the convention, that have quite different views from the ones that we have. They have different standards, they have different legal courts and different legal talents and different legal judges. And the result has been, and to an extent I would go only this far with Jonathan Sumption, but not too far with him, because I think he's extreme and quite wrong, that the Strasbourg court has gone rather further than it should have done. But nevertheless, I would definitely not come out of the convention. And there's another sort of final point from me, and that is that there's something sort of faintly absurd about the concept that we would get out of the convention and then promptly legislate a precise replica of the convention for domestic law purposes. And that does seem to me to be rather wasteful. I think we would do very much better to overrule that Bingham decision and make it clear beyond doubt that we were not bound here by decisions in the Strasbourg court, but that we would obviously give proper respect to those decisions, and that actually could resolve the problem. But I think that would probably require primary legislation.
Okay, Liz Gloster.
Well, I speak really as a European as opposed to a judge on this. I absolutely agree with what Tony says, but I think that it would be appalling if we were to leave the European Court of Human Rights. We set it up, we were instrumental in the purpose of the thing, the functioning of the thing, and the fact that now we're a little bit dissatisfied with it because maybe we don't like the way some of it is going is no reason for abandoning our European colleagues on this particular stage. The judges that I spoke to when we left Brexit, when we left the EU, felt they'd been betrayed by us in a way, because it all emerged, the European Union emerged out of the aftermath of the Second World War, and the ECHR has done so even more so. And I think we'd be betraying Europe if we left, but that's not speaking as a judge, that's speaking as a European. And I mean, I'm with Ian Burnett on this. We've got to stay. We can't just leave. And there's very little actually in there, if you do an analysis of the cases that we might not like as Brits, that actually impacts.
But what about Jonathan Sumption's point? And we've just recently had a ruling that exemplifies this on climate change, which is another ruling which people feel, or some people in the government feel, is overreaching the remit of the court. Charlie Falconer.
Sorry, just let me finish on that. Well,
yeah.
Tony's answer is the correct response to that, isn't it? We don't need to, if our
we shouldn't be bound by it, is
we
what
shouldn't
you're
be
saying.
bound by it.
Okay.
I agree with what David, Tony and Liz have said and all the reasons that they've given. I would just make one additional point. We don't have a written constitution. We don't have a Bill of Rights like America does. We don't have judges that hold the state to some basic freedoms. And the rule of law depends, or the purpose of the rule of law is to ensure that there are some irreducible rights that people have. If we aren't a member of the European Convention on Human Rights, then there is no person who decides what our irreducible minimum is beyond Parliament. They can pass any law they want, and there will be nobody, because the European Court of Human Rights will not apply at that particular point, to say that we've infringed those rights. And regularly, over time, Labour and Conservative governments, since we joined since it became part of our domestic law, have gone too far in the laws that we passed. So, for example, after 9/11, the Labour government passed laws saying you could lock up without trial foreign nationals that people thought might be a risk to the state, but not nationals. And the House of Lords, as it then was, the predecessor of the Supreme Court, led by Tom Bingham, said that breaches the European Convention on Human Rights, and made a declaration to that effect, and then the government changed the law. If you've got no independent means of working out whether those rights are being infringed, and you wouldn't have, because Parliament, remember, is controlled by the executive in our system, then there would be no proper protection.
But you have our Supreme Court.
Yeah, but our Supreme, if for example, there was no European Convention and the Labour government had passed that law, which we did do, the Supreme Court would be absolutely powerless to do anything about it. They would simply have to say, this is the law, and give effect to it.
Well, I think to give Jonathan Sumption's other bit of his argument, he wouldn't want to see us pull out without creating a British Bill of Rights.
But then the Bill of Rights could be amended at any time by Parliament. So what we would have done in 2003 after the terrorist attacks would have said, we'll just change the law in relation to it and say, this is the law, you should be able to lock them up because it's an emergency, here's a piece of primary legislation. What could the Supreme Court do? Nothing.
I think that raises quite an important point that ties in with what was discussed earlier about the view of judges. I think one of the reasons why in this country the judges are relatively free of much criticism is because they don't have much political power. We don't have a constitution whereby they can override Parliament. The price of that is, as Charlie has said, that Parliament has a great deal of power and there's not much the judges can do about it if they enact a very unattractive piece of legislation and do it in a way that the judges can't get round. On the other hand, it means that the judges are kept out of the political arena largely, and that ensures that they are less open to criticism.
I strongly agree with what David has said about the fact that because the judges are not in play in the way that American US Supreme Court justices are, they retain their high standing because they're not perceived to be political. And it's that risk going forward which is the real risk to the judges, I think.
Yes, I'd like to pick up on that now and move to the rule of law issue, because David made a very interesting point. With the increase in secondary legislation, Henry VIII clauses, matters not being properly debated by Parliament, no time, more issues will go before the judges. They will have more power. People will then clamour for some kind of election of judges so that we know their politics. Who would like to take that point? Is that a worry for the future? David, perhaps you set that ball rolling.
Well, first of all, this point about secondary legislation. As you probably all know, there are statutes that are passed by Parliament, and then there's secondary legislation, statutory instruments, which are really made by ministers and the executive and laid before Parliament. And although Parliament nods them through, they are treated as decisions of the executive. Originally, statutes, primary statutes, were the law, and that was made by Parliament, and the courts couldn't interfere with them. Statutory instruments were used for minor administrative details and so on. Increasingly, in different ways, statutory instruments are increasingly used to bypass Parliament and give more and more power to the executive and stop Parliament really considering statutes. That is an undermining of the democratic process, undermining of good lawmaking. There's a price to pay for that if you're the executive, because secondary legislation, statute instruments, can be reviewed by the courts, and the courts can say, this may be what this statute instrument says, but it's unreasonable, or it doesn't comply with the primary statute under which it's made, and they can quash it, which they can't do with a statute. But as a result, the more and more statutory instruments and the less statutes you have, the more judges get involved in lawmaking, and the greater the risk, as Charlie has said, of judges being seen to be political. At the moment, I don't detect much appetite for judges politicians being involved in judges' appointments, other than in the very residual way in which they are now. The political, the Judicial Appointments Commission, which has no politicians on it, majority of lay people, but just a small majority over the lawyers. They appoint the judges. Technically, it goes to the Lord Chancellor, the Prime Minister and the Palace for approval, but in practice, it's almost always nodded through.
I mean, I'm sure that's right. Tony Grabiner, I mean, is there a danger? We do, though, don't we, have a tension between judges and politicians. Politicians already feel that judges are blockers, if you like, to policy. So, and could this only get worse?
Well, this is the Judge Over Your Shoulder paper that was distributed, as I recall, not even by Labour, actually. I think it was pre-Labour, where all civil servants of any seniority were given a pamphlet called The Judges Over Your Shoulder to make it clear to you that your decision-making process could be the subject of some evil judge, you know, who might undermine you. Let me just come back to the point in a moment, but I just want to emphasise one point that may not be apparent to everybody. When David talked about delegated legislation being nodded through, it's very important to understand exactly what that involves. I think there's a convention that, I mean, literally it is nodded through. There is a convention that the delegated legislation is not debated, certainly not in the House of Lords, probably not in the House of Commons either. So the result is that, and it's happening more and more, that you see a bill arriving, for example, in the Lords, which makes frequent reference throughout the provisions. We're giving power to the minister to make various terribly important delegated legislation, indicating the scope of that legislation, but not telling you very much more than that. And this is deeply resented by across the House, certainly in the Lords. I don't know about in the Commons, I've never been in there. But I think this is very, very unsatisfactory. And of course, it's very attractive to senior civil servants to be encouraging ministers to adopt this mechanism in order to get through the delegation process, get to achieve what they want to achieve without there having been any proper debate about it at all, in Parliament.
Yes, so I suppose
it's very unsatisfactory.
It's unsatisfactory. So we've got this democratic deficit. My point is, or the question really is, are judges going to be stepping in even more to fill that? And is that a concern?
I mean, the danger is, danger in terms of politicising judges, but the risk is that the judge, first of all, will be familiar with the fact that the point has not been fully debated. He doesn't, or she doesn't have to give vent to that as part of their judgment. But the chances are that they will be encouraged to look very closely indeed at the action compared with the delegated legislation and comparing that with the primary legislation, possibly with a view to coming to the conclusion that actually the minister has acted beyond his powers. So I think it does provide more scope for politicising the process, which I think is a very bad thing.
Yes. Liz, do you want to...
Well, your original question, I think, was, is there going to be more political influence in the appointment of judges? So just answering that...
It was more to whether we would be leading that, there would be pressure to move that way.
Yes, I don't think so. I haven't seen any build-up, whether in the press. Okay, there have been a few articles, but I don't think we want to Americanise our appointment system. I don't think there's a political or a public yearn out there to make our judges the playthings of the political process, and certainly not at Supreme Court level.
Or any level.
Absolutely not. I completely agree that if you politicise, then you undermine the judges. The only bit of pressure for politicisation of judges came in the immediate aftermath of the prorogation decision, where the then Prime Minister, Mr. Boris Johnson, and his Attorney General both said this was the consequence of political acts by the judges in the Supreme Court, and that therefore there would need to be more politics in the appointment of judges. Happily, that was impossible because of the Judicial Appointments Commission, and it faded away from there. But we would be really doing the polity of our country a huge disservice if we increase the politicisation. My sense at the moment, and I think David is right, where he says if you give more leeway to the executive to make decisions rather than requiring primary legislation, that there is potentially more scope for judges to intervene and strike down what is happening. My sense at the moment is the judges are not going in that direction at all, that they're being incredibly judicious about the circumstances in which they will intervene or make declarations that something is incompatible with the Convention. And Lord Reid, the current President of the Supreme Court, in a case about the two-child rule, said we won't let the courts be used as a means of prolonging debates that pressure groups advanced in Parliament and now advance in court. And if Parliament has passed a particular provision, then broadly, whether it be by secondary or primary legislation, we will not intervene to say that that was something that shouldn't have happened, which is a difference in tone to what Lord Bingham said when he struck down the foreign nationals can be arrested without trial, but the nationals can't.
Okay.
So there is a retreat, I think, from willing to be interventionist.
Well, but just very finally and briefly, if you all could, on the number of the judges in the programme, I'll call it programme, the video, expressed concern about the rule of law. Lord Phillips described it as a religion, and I wonder whether there's a feeling, certainly judges seem to express this, that religion had been lost and that our ministers and politicians just didn't get the constitutional niceties in the way they ought to. Is that your view? And I have to start with you, Charlie Falconer, because a lot of them put it down to the change. Well, about you personally, but you were there at the time. Yes, abolishing the old tradition of the traditional role of the Lord Chancellor, standing up for the judges. They put it down to that. And I think some of them, and Lord Burnett is one, would like to see that role reinstated. Not all the reforms abolished, but that one.
There is a fundamental fissure between politicians and judges in a way that there was not 60 years ago and 70 years ago. In 1918, when the most important relationship we had as a country was with America, Lloyd George, the Prime Minister, appointed the Lord Chief Justice, Rufus Isaacs, to be the ambassador to America because he was a fundamentally brilliant politician, Rufus Isaacs. In 2021, when he needed a Viceroy of India, he appointed Rufus Isaacs to do the job. They were absolutely aligned, the judges and the politicians. In 1955, when Rayner Goddard, the Lord Chief Justice, sentenced Derek Bentley to death, and he was 18 years old, and he was in police custody at a point where his confederate, who was not in police custody, shot a policeman dead. And Rayner Goddard said to the Home Secretary, David Maxwell Fyfe, don't reprieve him, let him hang. They were absolutely as one at that particular point. The judges and the politicians were completely aligned. That has not been the position since the early 70s. We are, the judges on the one hand and the politicians on the other, come almost from different parts of the forest.
And why is that? Because
politicians, barristers don't now form the great corpus of people who are in the Commons. The law has its own rewards, where, as it were, commercial law, civil law produces rewards in a way that have vastly outstripped the way that people like Patrick Hastings, the best advocate of his age, became the first Labour Attorney General. That was regarded as perfectly normal. They're now separate. And as a result of them being separate, this idea that the Lord Chancellor could say to everybody, oh, stop, don't do that, and they'd all say, yes, we agree, was on the basis that they all came from the same sort of place. But they don't anymore. And it's just not possible, nor is it constitutionally right, for the head of the judiciary of England and Wales to sit in the cabinet, to be the chair of the final court of appeal, the Supreme Court, where the main litigant in front of the Supreme Court at the moment is the government. So it's just, it had to come to an end. And then the idea, and Ian Burnett has this idea, that you have a sort of free-ranging legal figure who says, don't do that, when everybody's saying, you know, who is this person? He's got no connection with politics. It just, the world has moved on,
Yeah.
and rightly so,
Okay.
but the judges are much more independent.
David Neuberger, what do you think?
Well, I think that the way that the Lord Chancellor, the historic Lord Chancellor, worked, looking at the last two traditional Lord Chancellors, Lord Mackay, who was on that film, and Lord Irvine, shows that it was working. But I do think that Charlie is right, that the point had come where it couldn't be continued. You couldn't have somebody who was a member of the cabinet, the senior judge in the Supreme Court, and the Speaker of the House of Lords. Something had to change. And I think the real problem was how to effect the change. And I don't think the change has worked, but I'm not sure how one could make the change better. I suspect one view would be, if it was possible, to say that the Lord Chancellor should not be a career politician in the House of Commons, who sometimes isn't even a lawyer, but should be a highly respected lawyer who, if necessary, is appointed to the House of Lords. So he or she is not somebody who is out to improve his or her political career. He or she is somebody who is highly respected as a lawyer. And I think that would be worth trying.
Okay,
But
James
I do
Grabiner.
think it's a serious problem, and I do think that Charlie is right, that you couldn't have continued the old system.
I'm not sure I go along with that. I'm not sure I agree with Charlie. Just a couple of points. I mean, first of all, I don't think Rufus Isaacs, Lord Reading, is a very good example to support his point, because Rufus Isaacs was a politician to his fingertips. He was a member of Parliament, he was Solicitor General, he was Attorney General, and if he hadn't been Jewish, I think he would have been Lord Chancellor as well. And so the
Lord
idea...
Chief Justice.
So he was Lord Chief Justice.
And the Viceroy of India.
No, he was, and he was Lord Warden of the Cinque Ports, and he had all sorts of other things. He was a most astonishing person. I'd love to have met him. But he was a politician to his fingertips. It's entirely unsurprising that he would have lined up, you know, with whoever the Prime Minister of the day was to, you know, encourage him. And he went to America. He was the ambassador there, and he raised all the money, you know, following the First World War and so on and so forth. So he was a very talented bloke, but he was, believe me, he was a politician. My concern in this story is that effectively since, I was going to say since Derry Irvine, but maybe I should say since Charlie, we've had a long, long list of people who have occupied the office of Lord Chancellor. Some of them have been perfectly decent, good people. One or two of them have been absolutely appalling. And what concerns me, I wouldn't name Liz Truss, for example, but what really concerns me, on a very serious note, is that if you are really kind of regard it as being important that the rule of law should be respected, it is, I think, critical that somebody of seniority is sitting at the cabinet table who represents the law. And that was the position, for example, with one of the great Lord Chancellors, but is no longer the case. And I think that is an incredibly unsatisfactory state of affairs. And I also think that it undermines the standing of the rule of law and the judiciary in this country. As to what the solution is, I don't know. But David Neuberger's point about a non-political person in that position, I think is very, very important. I also think that historically, depending upon the personality and character of the individual appointee, those people have done a fantastic job, notwithstanding this kind of odd feature of the British Constitution of somebody who's judicial and at the same time, you know, is sitting in the cabinet as a politician. The fact is that the Lord Chancellor of the day would never sit in what was then the House of Lords, the final court of appeal, in anything that was remotely politically controversial. So that to a large extent, the potential for the problem, you know, was done away with. As I say, I don't know what the answer is.
No, right. Finally, Liz.
Finally, because I'm the non-parliamentarian here, what do I know about what goes on in the corridors of power? What I think is a really good
And you're
thing,
not in the Garrick.
Not
Not
yet.
yet.
Not yet.
Not yet. I'm happy
Watch
to
this
propose
space.
you in a couple of weeks.
But what matters to a judge, I think, is that we are fiercely independent, and not having the Lord Chancellor being in the cabinet and appointing us, I think is a good thing, because it means that if you're not on the right side of the street politically or on the left side of the street politically, your chances aren't undermined. You can still get there, and maybe not become Lord Chief Justice, but you can still get there. So I think it's a great thing. I think the tension between the judiciary and Parliament is a good thing. And I think that energises the whole system. It enforces our independence. And I like that. And the answer is, I think, not to have necessarily a lawyer being the Lord Chancellor. Okay, we've had some lousy ones who aren't lawyers, but it doesn't necessarily mean that having a lawyer
some good ones.
there...
And one or two good ones.
And some very good ones. But it doesn't necessarily mean it's a good thing to have somebody who's a non-lawyer. Because a lawyer, was it David's example of having a senior lawyer in there in some sort of kingly position? Again, they could be the politician's poodle.
Indeed, and it's a most interesting historical fact that in modern times, no Lord Chancellor has ever resigned on a point of principle.
Yeah.
No, they get the sack.
Well, that's a very
the
good...
light of the long knives.
That's a good point to end this particular discussion and throw it open to the floor. Who would like to ask a question? There's one there.
My question, I guess, a lot of my questions I came in with were actually answered by the panel as you went along. But one of the questions I wanted to ask was about the Constitutional Reform Act and one of the impacts it's had. I know Lord Falconer has been a part of that. I know a lot of you experienced it as they went along. One of the things I've noticed, though, in relation to how the Act rolled out was by way of developing perhaps a more noticeable ecology within the judiciary, become even more independent from, let's say, political pressures, because the judicial, the JAC basically rolled out a much more open and transparent system of appointments as compared to the old system of secret soundings and taps and shoulders. So I'm just wondering, is that an observation that only I have, or does anyone else on the panel notice that the fact that the last 20 years, since the CRA, we do have a much more pronounced independence in the judiciary?
Well, I'm sure Charlie Faulkner would agree with you.
Well, I would.
The roundup on that question would have decisions like Miller 1 and Miller 2 under the bench in the 70s and 60s as compared to now.
I think that the Judicial Appointments Commission led to a very much greater distancing of appointments from the politicians of judges, though I would say myself, Lord Irvine, Lord Mackay, Lord Havers, Lord Hailsham, as it were, the last 50 years of Lord Chancellors were scrupulous in trying to appoint on merit and nothing to do with politics. And if you look at the appointments that they all, including myself, made, there was no political bias one way or another. And I appointed lots and lots of people who were conservative in their outlook with a capital C. But I do think the ecology that you are talking about is not limited to appointments. It also includes judges in terms of the administration of justice having a much more forceful role than they previously had, because they, particularly the senior members of the judiciary, were much more vocal and much more plugged in to the way things were organised, because the effect of the Constitutional Reform Act was to remove the Lord Chancellor as the head of the judiciary, to give that to the Lord Chief Justice, to then give senior judges administrative roles in the way the courts were run, and that has given them a much greater independence in relation to the way that we do things in court.
Anybody else like to comment on that?
I think it's quite difficult. I think that we started to see a big change in the judicial attitude probably around 1970. If you want to put a name case, probably the Annis Minnick case. And from then on, the volume of judicial review went up and up. And the other big change was the Human Rights Act took effect in 2000. How much the effect of the different ways of appointing judges was, is quite difficult to measure. And if you look at the judges who decided Miller won, I think the great majority were appointed as judges under the old system by the Lord Chancellor's appointment. In fact, I suspect that all of them were, apart from Lord Sumption. When it comes to Miller too, I'm not so sure. But I'm not sure that the way of appointing judges has made that much difference to the judicial independence and outlook. I think what we've seen, as I've said, over the past 50 years was increasing judicial, if you dislike it, activism, if you like it, increased judicial responsibility.
Did the Human Rights Act give judges more power?
Oh, without a doubt, yes.
So now are they more powerful, would you say?
Yes, undoubtedly. I think there are two main causes. One is the enormous growth of judicial review, which was partly judge-led, but partly, largely reflecting society's approach, reflecting the fact that we were a more questioning society, a more rights-driven society. There was enormous increase in regulation and government activity that meant more judicial review. And the other big change was the Human Rights Convention.
Would you go so far as to say the judges were the most powerful limb of the Constitution?
Nothing like, no. I would say probably of the three, the least powerful.
Okay.
Question at the back.
I just wondered if the panel think judges are paid enough, or are they paid too little, both to attract the best people to the jobs, and would that, if they were paid more, when they retired, would they have to sign petitions and go and do so many other things?
Can you hear that?
I couldn't hear the end of your question.
Yeah, what was the end?
I heard the beginning. Were we paid enough? Are we paid enough? But what was the last bit of your question?
If they're paid more, would it stop them going on and doing other things which may run the risk of politicising their colleagues who are still sitting? For the reason that Lord Grabiner said before, when he said judges should shut up, ex-judges should shut up, because it makes people think perhaps they were political when they were on the bench.
I mean, at the relevant time for me, I thought judges were grossly underpaid, which is why I never became one. And I suspect that we should pay our judges more. But the trouble is, if you say that to the great British public, they fall about laughing for understandable reasons, because they think that lawyers are all overpaid in any event. So it's not realistic, I think. In any event, I can't believe for a moment that if they were paid more, I mean, if you paid Jonathan Sumption now a lot of money as a judicial pension, I don't think it would make the slightest difference to his outpourings.
I agree with Tony. I don't think Jonathan Sumption's talking on the media is because of the money. I'm sure the £150 he might get is not remotely motivating him one little bit in relation to it. I think as far as paying judges more is concerned, in a period of time when we've had however long it is of austerity, it seems to me very difficult to single out judges for special favours in relation to public sector pay. The acid test of whether or not they're being paid enough is, are judges being recruited and retained at the right quality? And my sense at the moment is that the quality of judges is incredibly high. There may be specific parts of the judiciary, not the High Court, not the Court of Appeal and not the Supreme Court, but there may be specific areas in the judiciary where there are problems about recruitment and retention, and that may require some tinkering with the salary scale there. But broadly, I can't see a case for a massive increase.
Well, the whole problem of judicial pensions was sorted out, wasn't it?
Yes,
and I
it
think
was.
That's gone away, and that has stopped being a deterrent to people coming on the bench. Any more questions? Well, while people are thinking, I'd like to ask this. What can, if there is an incoming Labour government, what can we look to see for the justice system?
Well, I mean, the justice system is in a very bad way at the moment.
What do you mean by the justice system?
I mean the criminal justice system, the family justice system, and the civil justice system. So in relation to the family justice system, dealing with private law disputes about money and children, the public law family system, should children be taken away from their parents because there's a level of care not being provided, the criminal justice system, in particular the trial of cases in the Crown Court, and the civil justice system, particularly the collection of debts by people, the commercial court system.
I was just going to say, don't you slag off my commercial court, Charlie.
Could I say,
the commercial justice
Liz,
system is in an excellent place.
The commercial court system is in a most excellent place, and that may have something to do with the fact that the funding of the commercial court system comes exclusively from the parties, who are incredibly wealthy. So they are by and large funding lawyers on both sides. The problems with the rest of the system is it's publicly funded, and that's causing a difficulty. I would not necessarily think that there's going to be massive more amounts of money for the justice system, because I think everybody agrees at the moment there are huge problems about increasing public expenditure, and I suspect, because this is what politics is like, health and education may look more like favourable targets for increases in public expenditure than the justice system, though it will become an increasing problem unless, as I said earlier, you solve the bottleneck with the prisons, and you've got to solve the bottleneck with the prisons in order to make the system move faster.
A key part of the justice system is the courtroom. And one of the problems about our courtrooms, I mean, this is very true in the criminal courts. You know, there are buckets in the court underneath dripping ceilings and stuff like that. There are loos that don't function. There's no water running and so on. I may say also, I had a case a few weeks ago in the commercial court, it's actually in the Chancery Division, but in the Rolls building, which is the leading building for commercial cases in the whole of the UK, where the room temperature was basically a gross breach of all the health arrangements. And I bitterly complained to the judge, who put his hands like that and said, nothing I can do about it. I ended up writing a letter to the Secretary of State for Justice, and he actually did something about it. But the temperature arrangements over there are appalling. And so will Labour spend some money on improving our court structures? The commercial court, don't worry about it. But what about the typical magistrates' court across the country, which are, you know, just in an appalling condition?
Quite, and they deal with 90% of the cases. Jonathan?
Should judges be allowed to join any private members' club they like?
Liz?
Yes, absolutely. Anybody should be allowed to join what private clubs they want, as long as they're not unlawful private clubs carrying on unlawful business. Of course, speaking as a woman, I would love to join the Garrick. Of course,
we can fix that.
Thank you for a small consideration, no doubt.
Not even for a small consideration.
But why? Sorry?
Why would you like to join the Garrick?
Because they've got lovely pictures, wonderful pictures. But no, joking apart, I think judges should be allowed to join private members' clubs, whether they're male, female, whatever. That's individual freedoms. No, I don't think that judges should have to resign just because they're a member of this club or that club, or this golf club, that golf club. And I think it's unnecessary. Having said that, of course, I think women should have the possibility of joining clubs they want to join. But I think it's for the private members to decide that.
Yes, Tony Grabiner.
Well, I think it's all nonsense. There's a huge debate about this suddenly. One of the curiosities in this story is that in relation to the Garrick, can I disclose an interest, along with at least 3 other people around me, and the fourth won't be long now because they're going to change the rules, is that, I can't even remember the point I was going to make. Anyway,
I'm sure it was a good one.
Anyway, I'm sure it was a good one, but I think this is all nonsense. Most of the people who are kicking up a stink about this themselves were nominated They agreed to be nominated and became members of the Garrick Club. Suddenly now they're very upset about discovering the fact it doesn't have any women members. So I think they're all a bunch of hypocrites. But I am strongly in favour of women members of the Garrick Club, and I'm confident that in the very near future it's all going to change. And I am prepared to nominate Liz Gloster.
Oh, thank you,
Well,
Tony.
watch this space. David Neuberger.
I haven't got a great deal to add. I think, first of all, I've been a member of the Garrick, I think, all the time I was a judge. And it was in my entry in Who's Who, and it was commented on occasionally in newspapers. Brenda Hale was very cross with me for being a member of the Garrick, but otherwise, some of my women colleagues on the bench actually asked me to nominate their husbands, second their husband's nomination to be members of the Garrick. There was quite a difference. What slightly troubles me, and I would have said what Tony and Liz have said, until quite recently. But I do think one has to accept that that changes in perception happen. And I begin to wonder whether there is a perception, and possibly it's a knock-on effect of the Human Rights Act and equality, thoughts about equality and coming to the fore, that means that perhaps there will be perceived to be some justification among people who previously would have thought it was nonsense, for the fact that judges who are meant to stand for equality should not be members of clubs that do not include equality. And I have to say that, having been very much in Tony and Liz's camp, I'm slightly wondering whether we are seeing a sea change and people of our age aren't necessarily appreciating what changes have happened over the past 20 years.
Mm-hmm. Thank you. I think probably we're going to have to draw it to a close unless there's another really burning question, but you can carry on over a drink. So I'd just like to thank again our very distinguished panel. Thank you all very much for coming, and particular thanks to all the team at the University of Law, Lisette, Laura, Michael, Sophie and Ian, who've all worked incredibly hard on getting this on the road. Lord Grabiner, as President of the University, thank you for commissioning the series. And Lord Neuberger, I think, gets special thanks for all his time and support. He's actually appeared, or will have done after tonight, in 3 episodes, which I think is beyond the call of duty. So thank you very much for that. Thank you. This podcast was brought to you by the University of Law.